Patriots, the Supreme Court just made a move that has every gun owner on the edge of their seats. We're talking about the fate of the AR-15, America's most popular rifle, and whether the Second Amendment actually protects your right to own it. The Supreme Court has relisted the Cook County rifle ban case for a third time. They've also relisted the Duncan magazine ban case. And folks, this is huge because the data shows that cases relisted multiple times have a significantly higher chance of being granted review. Justice Kavanaugh promised this issue would be addressed in a term or two. Well, time's up. The Supreme Court can't avoid this question forever. Are AR-15s protected by the Second Amendment or not? Before we break down this explosive development, smash that subscribe button and hit the bell. We're at 650,000 subscribers fighting for gun rights. Let's get to 1 million. Let's dive into what's happening right now at the Supreme Court. The fundamental question, and let me start with a question that's at the heart of this entire case. And it's a question that should shock you that we even have to ask. Does the Second Amendment guarantee Americans the right to possess AR-15 rifles and standard capacity magazines? Think about that for a second. The AR-15 is the most popular rifle in America. There are an estimated 2.025 million AR-15 style rifles in civilian hands. It's used for home defense, sporting competitions, hunting, constitutional militia purposes, target shooting, and training, and yet circuit courts across America are saying nope. The Second Amendment doesn't protect these rifles. Some courts claim AR-15s are too militaristic to be protected. Others say they can be restricted even if they're protected arms. The confusion is massive. This is why the Supreme Court must step in. Americans deserve to know whether their constitutional rights actually protect the firearms they already own. The Cook County case, BACKGARON-DLS, talk about the main case heading to the Supreme Court. Vermonte v. Cook County. Illinois, this case was filed back in 2021 in Federal District Court in Chicago. The plaintiffs' individual citizens, along with the Second Amendment Foundation, challenged Cook County's ordinance that makes it a crime to sell, transfer, or even possess so-called assault weapons. We're not talking about machine guns here. We're talking about standard semi-automatic rifles that millions of Americans own legally. The plaintiffs argued that this ban doesn't just regulate firearms, it outlaws some of the most common and popular rifles in America, which should be protected under the Second Amendment. Now here's where it gets complicated. While this case was pending, Illinois passed a statewide assault weapon ban in 2024 that overlapped with Cook County's restrictions. So now we're dealing with both county and state bans. Around the same time, the Seventh Circuit decided a different case called Bevis v. Naperville, and in that case, the Seventh Circuit upheld Illinois' assault weapon ban. Their reasoning: they claimed AR-15s are too militaristic in nature to be protected as arms under the Second Amendment. Do you see the problem here? The Seventh Circuit is using a test that was never part of Heller or Brune. They invented this too militaristic standard out of thin air. The District Court because the District Court in the Cook County case was bound by the Seventh Circuit's ruling in Bevis. They had no choice but to uphold Cook County's rifle ban. The District Court issued summary judgment in favor of Cook County. The plaintiffs appealed, but in 2025, right after the Supreme Court denied review in the Maryland Snope rifle ban case, the Seventh Circuit affirmed the lower court's decision. So now the plaintiffs are seeking Supreme Court review, asking the court to finally resolve this critical question. Do Americans have a constitutional right to own AR-15s and similar semi-automatic rifles? The petitioners make a powerful argument. Circuit courts are split and deeply confused about how to apply Heller and Brune. Some courts say AR-15s are protected arms but can still be restricted. Other courts say they're not protected arms at all. Some courts use a militaristic test that doesn't exist in Supreme Court precedent. Other courts use common use tests but then ignore the fact that AR-15s are incredibly common. This confusion must be resolved by the Supreme Court. Cook County's weak DFE&S. Now let's talk about how Cook County is trying to defend their ban and avoid Supreme Court review. Cook County filed a brief arguing that the Supreme Court should deny review and kick the can down the road once again. Their arguments are frankly pathetic. First, they claim there's nitrogen monoxide circuit split on rifle bans. They're basically saying all the circuits agree with us, so there's no conflict to resolve. But that's absurd. There are circuits that have struck down some gun restrictions, while others uphold identical laws. The confusion is obvious. Second, they claim this case is a poor vehicle for Supreme Court review because the plaintiffs allegedly skipped procedural requirements, rushed discovery, and didn't offer enough evidence. In other words, Cook County is trying to use technicalities to avoid addressing the actual constitutional question. They don't want to argue the merits because they their position is weak. So instead, they're hiding behind procedural excuses. This is exactly the kind of game playing that anti-gun jurisdictions use to avoid accountability. The Duncan magazine ban, CHS, there's a second critical case that's also been relisted. Duncan v. Bonta, the California magazine ban challenge. This case challenges California's ban on magazines holding more than 10 rounds. And just like the rifle ban case, it's been bouncing around the courts for years. Here's what's fascinating. The Supreme Court actually already GVRD'd this case once. That means they granted review, vacated the lower court decision, and remanded it for reconsideration in light of Brune. But what did the Ninth Circuit do? They came back and upheld the magazine ban again. They basically ignored Brune and said, nope, magazines aren't protected. So now the plaintiffs are back at the Supreme Court saying, you gave them clear instructions in Brune. They ignored you. Please step in and correct this. Both the Duncan magazine case and the Vermonte rifle case are being relisted together, which suggests the Supreme Court is considering them as a package deal. The relist Saigian. Now let me explain why these relists are so significant, because this is critical information. When the Supreme Court receives a petition for certiorari, they hold a conference where the justices discuss whether to grant or deny review. Most petitions are simply denied at the first conference, but sometimes the court relists a case, meaning they postpone the decision and schedule it for another conference. Why would they do this? Several reasons. Some justices want more time to review the cassettier, waiting for related cases to be decided. There might be internal disagreement about granting review there, considering granting the case but need to resolve questions. Here's the key statistical data. According to Supreme Court analytics tracking cases from 2016 to 2020, between 31% and 43% of petitions that were relisted at least once were eventually granted review. Between 66% and 75% of all cases that were granted SAT were relisted at least one time. In other words, if a case gets relisted, its chances of being granted skyrocket compared to cases that are just denied at the first conference. Now, both the Vermonte rifle ban case and the Duncan magazine case have been relisted twice already. They've survived multiple conferences where other Second Amendment cases were denied. The cases that didn't SURV, let me put this in perspective by telling you about the cases that didn't survive. At the first conference, the Morgan machine gun ban challenge was denied. That case didn't even get a single relist. At the second conference, the Rush and Robinson NFA short-barreled rifle challenges were denied. Those cases challenged NFA restrictions on SBRs and were also rejected. But the rifle ban case and magazine ban case, they survived both of those conferences. They keep getting relisted. If the Supreme Court had no side interest in these cases, they would have simply denied them like they did with Morgan, Rush, and Robinson. The fact that they keep relisting these cases suggests that at least some justices are seriously considering granting review. Now, I'll be honest, multiple relists can sometimes be a negative sign. If a case gets relisted 3, 4, or 5 times, it often means the court is preparing to deny it, but might issue a dissenting opinion explaining why. But so far, we're only at TWO relists, and these cases have survived conferences where similar cases were denied. That's actually a good sign. Kavanaugh's PRO. So let's talk about Justice Kavanaugh's promise, because this is critical. Last term, when the Supreme Court denied review in the Snope v. Brown Maryland rifle ban case, Justice Kavanaugh issued a statement. He wrote that while the court was denying review in that particular case, the time would come soon where they would need to take up a rifle ban and address this issue directly. He said this would happen in a term or two. Well, guess what? We're now in a term or two later. Time's up, Justice Kavanaugh. The plaintiffs in the Cook County case are explicitly pointing to Kavanaugh's statement and saying, "You promised you'd address this issue. Here's your opportunity." The question is, was Kavanaugh's statement a genuine promise that the court will take up rifle bans soon? Or was it just empty words to placate gun rights advocates while continuing to avoid the issue? We're about to find out. What happens ex extenso? What's the timeline moving forward? Here's what to watch for. Immediate future. The Supreme Court hasn't scheduled the next conference date yet because of the upcoming holidays. There are no official conferences at the end of December. Early January? The first official conferences of the new year will likely be scheduled for early January, probably around January 9th or shortly. After prediction, both the Vermonte rifle ban case and the Duncan magazine ban case will likely be relisted a GAIN for those early January conferences. Possible outcomes. Option 1. Grant review. The Supreme Court grants SAT in one or both cases. This would be huge. It would mean we'd get oral arguments in 2025 and a decision by June 2026. Option 2. Deny with dissent. The court denies review but issues dissenting opinions explaining why they believe SAT should have been granted. This would be disappointing but might signal future willingness to take similar cases. Option 3. Continue relisting. The court relists these cases, again for future conferences. This keeps hope alive but extends the uncertainty. Option for outright denial. The court simply denies review with no explanation. This would be the worst outcome and would signal the court isn't ready to address rifle and magazine bans. Why the court keeps avoiding islet. Me be honest with you. The Supreme Court has avoided rifle and magazine bans like the plague, and I think we need to discuss why. Political pressure taking up AR-15 bans is massively controversial. If the court strikes down these bans, Democrats will go insane. They'll call for court packing, term limits, you name it. Fear of backlash. If the court strikes down rifle bans and then there's a mass shooting involving an AR-15, the media will blame the Supreme Court. The justices know this, and it makes them hesitant. Incrementalism. Some justices might prefer to strengthen Second Amendment protections gradually rather than with one big ruling on AR-15s. They might want to build up more precedent first. Internal disagreement. There might be disagreement among the conservative justices about how to handle this issue. They might not have 5 solid votes for the outcome they want, but here's the thing. The Supreme Court can't avoid this issue forever. Circuit courts are in chaos. Americans don't know if their constitutional rights protect the firearms they own. The court has a duty to resolve this question. What this means for gun owners. You're a gun owner, especially if you own AR-15s or standard capacity magazines. Here's what you need to understand. First, the stakes are enormous. If the Supreme Court rules that AR-15s and magazines are protected, it could strike down bans in multiple states. California, New York, Illinois, Maryland, Connecticut, Massachusetts, all their bans could fall. Second, but if the court rules against gun rights or continues to avoid the issue, then more states will pass bans. The anti-gun movement will be emboldened. Third, these cases won't be decided quickly. Even if the court grants review in January, we won't see oral arguments until fall 2025, with a decision coming in June 2026. Fourth, support legal organizations fighting these battles. FPC, SAF, GOA. They need resources to take cases to the Supreme Court. Fifth, stay compliant with current laws. Don't assume bans will be struck down before they're actually struck down. Protect yourself legally. Sixth, pay attention to the reasoning in any Supreme Court decision. How they rule matters as much as whether they rule in our favor. All right, Patriots, that's the complete breakdown of where these critical rifle and magazine ban cases stand at the Supreme Court. Let me summarize the key points. Supreme Court relisted both rifle ban and magazine ban cases, TWICE. Cases survived conferences where other 2A cases were denied. Statistical data shows relisted cases have 31 to 43% chance of being granted. Justice Kavanaugh's promise to address rifle bans in a term or two is coming due. Next conferences likely in early January 2025. This could determine the fate of AR-15s and standard magazines nationwide. The Supreme Court cannot avoid this question forever. Americans deserve to know whether the Second Amendment protects the firearms they already own. Justice Kavanaugh, we're watching. Will you keep your promise, or was it just empty words? If you found this breakdown valuable, smash that like button. Share this with every AR-15 owner you know. Subscribe and hit the notification bell for updates when the Supreme Court makes their decision. Comment below. Do you think the Supreme Court will finally take up rifle and magazine bans? Or will they continue to avoid the issue? I want to hear your predictions. Remember, the price of liberty is eternal vigilance. We must keep pressure on the Supreme Court to do their job and protect our constitutional rights.